Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your free video resource to assist you in your subrogation and recovery matters. In this video, we'll be discussing assumption of risk and how it may be a defense to your claim. Assumption of risk is premised on the fact that certain activities are so inherently or obviously dangerous that if a party is injured or sustains damages, we're not going to hold someone else responsible. There's primary assumption of risk, in which the court will look at the activity itself. It doesn't care about the conduct of the parties, it just looks at what is the activity and should a party know that this is a dangerous activity and they could be injured. Consider professional athletes or NASCAR drivers. There's some inherent risk, and if there's a crash or if there's a collision and they become injured, we're not going to hold someone else at fault for that injury. The secondary assumption of risk actually looks at the party's conduct. And in this case, usually the plaintiff has to know that the defendant was negligent in some way, and the plaintiff continued on with their conduct anyway. If you went to a local hardware store and wanted to rent a chainsaw, and the clerk said, sorry, I can't rent you the chainsaw we have, it's sparking, it's not safe, and you say, no, it's okay, I work with chainsaws all the time, I can do this. They rent it to you, there's a spark, there's a fire, and you get injured. That would be secondary assumption of risk, because in light of and with knowledge of the risk, you went ahead and took part in that activity. Another distinction to make is implied assumption of risk and express. The express assumption of risk is any time that someone signs a waiver. Think of all the assumption of risk waivers you've signed in your lifetime. Whether it's something like downhill skiing or going bowling or anything like that, a lot of times that company will have you sign a waiver stating, I understand that there's risk in this activity and I'm not going to hold you responsible if I become injured. Implied doesn't require an oral or written assumption of the risk. Rather, the party's conduct shows that they appreciate the risk and went forward with it anyway. So where will you see this in a subrogation or recovery claim? One common area that we see frequently is car washes. An insured takes their car to get it washed, they drive up to the automated car wash, they proceed through, and when they come out on the other side, there's some damage, whether it's scratches or dents or anything that happens. Ohio courts have addressed this specifically and said that this is primary assumption of risk. A regular consumer should know that these automatic car washes use pressurized water and detergent and blown air to clean these cars, and that process has a risk of causing damage to the vehicle. It's clear, though, from these cases that if the car wash is negligent in some way, if it's more than just the regular conduct of going through the car wash that causes damage, but rather a malfunction, especially caused by negligence, where a metal arm maybe strikes the car, in that case, a car wash can be responsible. So even if there is an assumption of the risk in going through the car wash, the person going through the car wash is not waiving their right to recovery in all cases. They're not assuming every single risk that could be possible. Another example would be where a person is injured while riding in a vehicle driven by someone else. Let's take Peter plaintiff. He and his friend Dan defendant decide to go to a baseball game. Peter generously agrees to drive the vehicle. He gets in the car, he picks up Dan, they go to the game. And at the game, they decide to drink beer after beer after beer until they're both drunk. Now, they're both aware of this, and Dan says to Peter, hey, I know it's your car, but I'm a little bit bigger than you, I can handle this, you shouldn't drive, let me drive. And Peter says, okay, fine, you can drive my car. They drive home, defendant Dan gets into a wreck, and Peter's injured. Can Peter sue Dan for the injury? In this case, it would be a secondary assumption of risk type claim. Dan is drunk, and Peter is aware of that. Peter getting in the car with Dan under normal circumstances wouldn't be necessarily risky behavior, and so there would be no assumption of risk. But because Peter knows that Dan is drunk, and he gave him the keys, and he got in the car anyway, we're going to look at Peter's conduct. And that conduct says he knew he was drunk, yet he got in the car anyway. He assumed a certain amount of risk getting in the car. In these cases, the court treats that as a comparative fault defense, and it's going to prorate the comparative fault of each party and then reduce or bar plaintiff's damages. If you have questions about comparative fault and the different regimes that are out there, check out our On Subrogation video and podcasts on those topics. So what do you do when you're thinking about assumption of risk? One, you want to think, was there anything that our party, our insured, did that took on an obligation or assumed some risk in the activity? Or you want to look to see, is there any part of that activity that's just inherently and obviously dangerous, and therefore the defendant should not be at fault. In those cases, you want to still proceed on the claim, but be prepared for that defense to be raised. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.